Piracy. We have all encountered this phase before, especially with the widespread use of digital technology. Have you ever been a victim of piracy? Let me give you a few examples. Consider what would happen if someone hacked a movie before it got released and demanded a ransom for not publishing it on social media for free. Or assume the Money Heist web series on Netflix is publicly available on some social media platform. Piracy destroys not only a business model and creativity but also a sizable digital economy and a source of employment. To deal with piracy in India, there is a key legislation, the Copyright Act. Today we'll discuss one of the finest remarks made by the Delhi High Court against one of the biggest messenger apps, Telegram. The Delhi High Court recently heard a case brought by Neetu Singh and KD Campus Private Limited against the messenger giant Telegram. The case was related to piracy and unauthorized distribution of videos, lectures and books made and published by this education institute. The institute was pleading for a permanent injunction barring infringement of copyright damages and other reliefs in connection with the unauthorized distribution. During the court proceedings, Justice Pratibha M. Singh asked Telegram to disclose the name and VPN of all copyright violators. Meanwhile, Telegram argued in the court that its servers are located in Singapore and as a result, they are unable to submit such details to the court. Telegram further argued that it would be a violation of Singapore's data privacy law. Telegram's entire argument was centered around one point, that they are just an intermediary and it is beyond their control to curb such piracy. Taking note of the same, the Delhi High Court observed that copyright infringers cannot be permitted to seek shelter behind Telegram servers located in Singapore. The court further added that the IT intermediary guidelines and digital media ethics do not in any manner obviate the duty of Telegram as a platform to take all effective steps required to protect IP rights, including the rights of copyright owners. Court did not accept the logic of Telegram that it is just a mere intermediary and refuted it entirely. The court further stated that if infringers are allowed to hide their identity using technological means supplied by the messaging apps and their identity is not directed to be disclosed, the remedy of infringement damages would be rendered absolutely inconsequential. The court was of a view that as a result of granting an injunction without corresponding damages or monetary deterrence would be a toothless relief. Such orders do not prevent infringers from simply starting additional infringing channels and profiting from their infringement until the plaintiff, in the current case, the Education Institute, is able to seek an injunction against each such channel. Takedown or blocking orders are merely token relief for the plaintiff and without monetary relief of damages coupled with mushrooming of infringing platforms, the copyright owner's spirit to create and write may be considerably negated. The right of freedom of speech or the right of life, including the right of privacy, cannot be used by any person or entity, let alone an infringer, in order to escape the consequences of illegal actions. This is a very big remark passed by the court, where it is clearly mentioned that damages should be provided to the copyright owners whose rights have been infringed, who are copyright owners of course materials, being left completely remediless against the actual infringers, especially in order to claim damages and avail of other legal remedies in accordance with the law. If such argument is accepted in the current world where most disseminations happen through online messaging services and platforms, IP violations would go completely unchecked. The court thus directed Telegram to disclose the details of the channels or devices used in disseminating the infringing content, mobile numbers, IP addresses, email addresses, etc., used to upload the infringing material and communicate the same as per the list of channels filed. The court added that in the case if there are any further listings of infringing channels, the same be also submitted to Telegram. The court has given a 2-week time period to Telegram to submit all the information above of the copyright violator. Key takeaways from the Delhi High Court verdict. 1. Copyright owner can be compensated for the financial damages of the infringement of his or her content. 2. The social media platform, so-called the intermediary, can be made a party for such suits. And 3. Copyright owners, apart from taking down his or her content from the platform where it is illegally being broadcasted, can also take criminal action which is over and above civil suits. Don't be surprised in the near future if you don't get a free flow of channels and content that were available on Telegram. So if someone is pirating your content, you can sue not only the accused but also the intermediary platform through which such piracy is propagated and seek all financial damages, be it Telegram, WhatsApp, Facebook or any other social media platform. If you like the video, please consider subscribing and stay tuned for more videos like this. Thank you.